Hello and welcome दोस्तों. Today we will talk about another important article, that is Article 137 in the Indian Constitution. This article gives Supreme Court review power. So this review power is different from Article 13 review power, but because Article 13 comes into play when there is a breach of fundamental rights by the parliamentary law, right? But Article 137 gives Supreme Court power to review its own judgment, and orders. Right, Supreme Court can review its judgment or orders if there is a apparent mistake in the law or apparent mistake in the application of law, and where there is an error in the judgment. Right, in that case, Supreme Court can use Article 137 to review its own judgment. But this power is not absolute. There is certain limitations upon this power under Article 137, that this power is subject to the parliamentary control. So Parliament can enact law to restrict the court's review power under Article 137. Also, under Article 144, Supreme Court can frame certain law to regulate the power under Article 137. Also, there is a time limit. So within what time limit Supreme Court can review its own judgment. So there is a time limit under which Supreme Court can review its own judgment, and it is 30 days of time limit. Again, the bench composition, that what kind of bench should be composed in order to review its original judgment, right? So that is also limit. The purpose of this review power is to correct any clerical or factual error in the original judgment. So if the original judgment provides for the rigorous imprisonment, right, and if the law does not provide for the rigorous imprisonment, then one can go to the Supreme Court and ask for the review of its own judgment, right? Then there is apparent mistake in the application of law, right? This is another reason, and if new evidence is emerging, right, if new evidence is coming into light, then one can file a review petition to the Supreme Court to review its own judgment based on new evidence which can alter Supreme Court's original judgment. So this is not an appeal. Usually appeal challenges the correctness of the entire judgment, but review petition or the review power under Article 137 does not challenge the original judgment, but it focuses on specific error or omissions. If Supreme Court failed to consider certain evidences, then we can file review petitions, right? So this article we will look analysis later, but we will see what are the technical things under Article 137. So under Article 137 we can file curative petition, we can file the review petition. So both have similar connotation. First of all, we will file review petition, and if review petition is not accepted, then people go and look for application of curative petition. So let us see what is the difference. So review petition is filed when there is a clerical mistake, mathematical error, or new or important evidence was not available during the original judgment, but now it is available, right? Now new evidence is available which can alter the original judgment. Then a person can file review petition. But curative petition is filed when there is a clear or fundamental error of law. When there is a fundamental error of law, when the judgment is based on misinterpretation of the law, then can you file the curative petition, calling this there is a fundamental error in the law. Then threshold for consideration. So review petition has a relatively lower threshold, and the curative petition has higher threshold, which means that court can sometimes accept the review petition, but to accept curative petition, one has to give solid evidence that there is a need to review this judgment, right? So there is a threshold for consideration. The frequency, one can file multiple times on different grounds. So review petition can be filed on multiple times, right, based on errors or circumstances, based on new evidences, right? But curative petition can file once only as a last resort after review petition has been dismissed, right? Again, there is a time limit that a review petition must be filed within 30 days of the judgment, but for the filing curative petitions there is no formal time limit exist. Again, the review petition focuses on the correctness of the error on the record, right, which can be filed more frequently with a lower threshold for consideration. You can file multiple times, but curative petitions is the which file to address the fundamental error of law that have led to the miscarriage of justice, right. So this was all about article 137 and the two petitions, that is curative petitions and the review petitions.